Citizens United sought an injunction against the Federal Election Commission in the United States District Court for the District of Columbia to prevent the application of the Bipartisan Campaign Reform Act to its film Hillary, the movie. The Bipartisan Campaign Reform Act of 2002 is a United States federal law that amended the Federal Election Campaign Act of 1971, which regulates the financing of political campaigns. The movie expressed opinions about whether Senator Hillary Rodham Clinton would make a good president. In an attempt to regulate big-money campaign contributions, the BCRA applies a variety of restrictions to electioneering communications. Section 203 of the BCRA prevents corporations or labor unions from funding such communication from their general treasuries. Sections 201 and 311 require the disclosure of donors to such communication and a disclaimer when the communication is not authorized by the candidate it intends to support. Citizens United argued that, 1. Section 203 violates the First Amendment on its face and when applied to the movie and its related advertisements, and that 2. Sections 201 and 203 are also unconstitutional as applied to the circumstances. The United States District Court denied the injunction. Section 203 on its face was not unconstitutional because the Supreme Court in McConnell v. Feck had already reached that determination. The District Court also held that the movie was the functional equivalent of express advocacy, as it attempted to inform voters that Senator Clinton was unfit for office, and thus Section 203 was not unconstitutionally applied. Lastly, it held that Sections 201 and 203 were not unconstitutional as applied to the movie or its advertisements. The court reasoned that the McConnell decision recognized that disclosure of donors might be unconstitutional if it imposed an unconstitutional burden on the freedom to associate in support of a particular cause, but those circumstances did not exist in Citizens United's claim. The Supreme Court overruled portions of McConnell v. Feck. In the prior cases, the court had held that political speech may be banned based on the speaker's corporate identity. By a 5-4 vote along ideological lines, the majority held that under the First Amendment corporate funding of independent political broadcasts in candidate elections cannot be limited. The majority maintained that political speech is indispensable to a democracy, which is no less true because the speech comes from a corporation. The majority also held that the BCRA's disclosure requirements as applied to the movie were constitutional, reasoning that disclosure is justified by a governmental interest in providing the electorate with information about election-related spending resources. The court also upheld the disclosure requirements for political advertising sponsors and it upheld the ban on direct contributions to candidates from corporations and unions. In a separate concurring opinion, Chief Justice Roberts, joined by Justice Alito, emphasized the care with which the court handles constitutional issues and its attempts to avoid constitutional issues when at all possible. Here, the court had no narrower grounds upon which to rule, except to handle the First Amendment issues embodied within the case. Justice Scalia also wrote a separate concurring opinion, joined by Justices Alito and Thomas in part, criticizing Justice Stevens' understanding of the framers' view towards corporations. Justice Stevens argued that corporations are not members of society and that there are compelling governmental interests to curb corporations' ability to spend money during local and national elections.